Hey everyone, this is Mike. This is part 4 of the series on the Fourth Amendment. In this podcast, we're going to talk about automobile stops. Stopping a car is considered to be a seizure for the purpose of the Fourth Amendment. Generally, the police cannot stop a car unless they have at least reasonable suspicion to believe that a law has been violated. Now, when we talk about a law being violated, the most common type of law when it comes to automobile stops is a violation of a traffic law. So, for example, speeding, running a red light, changing a lane without signaling, things of that nature. However, reasonable suspicion to stop a car can also be based on a tip, perhaps a tip that is called into police headquarters advising, it could even be an anonymous tip advising law enforcement that a sports car of a specific make and a specific color with a specific license plate is transporting drugs. That in itself could give the police reasonable suspicion to stop the car. Now, there are special cases when law enforcement needs trump the Fourth Amendment rights of the drivers. In those cases, the court allows the police to set up roadblocks to stop cars without any individualized suspicion whatsoever that the driver has violated a law. So let me just go back again and restate that. There are special cases when law enforcement needs trump the Fourth Amendment rights of the drivers, and those are cases when the courts allow police to set up roadblocks to stop cars without any individualized suspicion that the driver has violated one or more of the laws that we just talked about. Now, there is a check on it. There's a 2-point test that the state has to satisfy before these roadblocks pass constitutional muster. They first the cars have to be stopped first on the basis of some neutral, articulable standard. An example might be every second car, every fourth car, every sixth car. The police cannot just arbitrarily decide to pick out certain cars in a roadblock. It has to be neutral. Second, the roadblock has to be designed to serve purposes that are closely related to a particular problem related to cars and their mobility. Now, you don't have to look too far to find examples of what the state would consider to be problems related to cars and their mobility. The drunk driving problem obviously is a problem that the state takes very seriously. It claims the lives of thousands of motorists and pedestrians every year. And so the gravity of the drunk driving problem is of a very high magnitude. And the courts have held that the state's interest in getting drunk drivers off the roads warrants or justifies police to set up roadblocks to check the sobriety of all drivers passing by. Another particular problem related to automobiles and their mobility that justify the police setting up a roadblock is this issue of the transportation of undocumented individuals. And this occurs primarily near the border, near the Canadian border and near the Mexican border. The Supreme Court held that because it's difficult for law enforcement to discern whether a car is transporting undocumented persons, police are authorized to set up roadblocks near the border to stop every car to check the citizenship of its occupants. In a case decided back in 1983 called U.S. versus Villamonte, the courts even extended that justification to include a suspicionless boarding of a boat in a channel that was leading out to open sea, and that was justified on similar grounds. Just as important is knowing what is permitted, what the police are permitted to do when it comes to stopping cars without individualized suspicion. It's also important to know when the police are out of line in stopping and using roadblocks to stop cars. Because remember, these roadblocks do away with any justification that the police needs to have, so that there is no requirement that there be reasonable suspicion to believe that a law has been violated. In a case that was decided back in the it was actually decided several decades ago. It's called Indianapolis versus Edmond. The police tried to set up roadblocks to check cars for illegal drugs, and the court slapped that down and said that it doesn't pass constitutional muster. The court reasoned here that the nature of a checkpoint like the one involved in this case, where it was set up to check cars for illegal drugs, is to detect evidence of ordinary criminal wrongdoing unrelated in any way to the use of cars or highway safety. So remember, that phrase has to continue to resonate in your mind. It has to relate to a particular problem related to automobiles and their mobility for a roadblock to be justified. And again, in the case where the police had set up roadblocks to check cars for illegal drugs, the court held that that did not relate in any way to the use of cars or highway safety. In fact, the court went so far as to say that if suspicionless stops were allowed under these circumstances, all suspicionless seizures would be justified. So the exception, the court was saying, would really swallow up the rule in that example. Now, let's get back to automobile stops and talk about what the police can order the occupants to do upon the lawful stop of a car. So to back up a little bit, what we're talking about here is a situation where the police have a lawful reason for stopping the car. And again, it could be due to a violation of a traffic law. It could be that the car was speeding. It could be that the car had ran a red light. It could be that the car had changed lanes without signaling. It could be that the blinker light on the back of the car was smashed up or was inoperable. Things of that nature. The license plate was hanging off of the car and it wasn't firmly plastered to the rear. Things of that nature. So we're talking about a situation where the police have lawful grounds to stop the car. Now, once the police stop the car, typically what happens is the police signal with their lights, and in some cases will even put their sound system on. The car pulls over to the side of the road. The officer gets out of the car and approaches the driver's side. In some cases, depending on where the traffic stop occurs, if it occurs, for example, on a highway, a busy highway, the police officer may actually approach the front passenger side as opposed to the driver's side. But there are all sorts of variables that go into what side of the car the officer will approach. But the first questions that usually come out of the officer's mouth are for the driver to produce license, registration, and insurance. Now, courts have held that if the officer's safety, if the officer feels that his or her safety is at risk, then the officer can order the occupants to get out. Now, by occupants, we're not just referring to the driver, but we're referring to everybody inside the car. So the car's driver as well as the passengers to get out. In addition, if the officer reasonably believes that the detainee, it could be a passenger or the driver, is armed and dangerous, then the officer can conduct a frisk of the detainee outside of the car. A frisk is basically a pat down of the individual's outer clothing to ensure that there is nothing dangerous that's on the person's that person's person that could harm the police officer. Now, this is where it gets a little problematic. The court in the Supreme Court, that is, in a case called Pennsylvania versus Mims, held that the police can also search the passenger compartment of the car to look for weapons, even after the driver and other occupants have been ordered out of the car. Now, it's not a stretch of the imagination to realize here that even if there is a weapon inside the car, the fact that the occupants have been removed from the car means that that weapon no longer poses any risk to the officer. Nonetheless, on this same grounds of officer safety, the courts have held that the police can search the passenger compartment of the car to look for weapons, even when the occupants are seated outside of the car, perhaps on the curb. So you can tell here that this can be misused by law enforcement as a way to get inside the car to conduct a search when they have a hunch that there could be something illegal. This can serve as justification for the officer to go inside and conduct a search of the passenger compartment. So it is problematic. Now, I want to talk about pretextual stops. So to set the stage here on a pretextual stop, what we're talking about here is a situation where the officer indeed has probable cause to believe that a traffic law has been violated. However, the officer's ulterior motive in stopping the car is to investigate whether some other law, not the traffic law that has been violated. So setting the stage, there's a police officer who observes a sports car with an out-of-state license speed by, and it's going maybe, it's exceeding the speed limit by, 15, 20 miles per hour. It's got an out-of-state license. The officer has grounds for stopping the car on the basis that a traffic law has been violated. But let's add a few additional facts. Let's say that this sports car, hot sports car, is speeding on Route 80, and it was seen just coming off of the George Washington Bridge and entering New Jersey. I believe that would be Fort Lee, but I'm not 100% certain. Now, the officer who sees this car pass by has been on the beat for a long time, and through his experience, he knows that that sports cars that are traveling, from the George Washington Bridge into New Jersey at a high rate of speed tend to carry drugs and tend to be transporting drugs. His suspicion is further aroused when he sees that the occupants inside the car are fairly young. By young, I'm talking about they look like 20-somethings, and they are kind of footloose and carefree. So the driver's true motive in stopping this car might be to get inside the car to check to see if drugs are being transported. Now, keep in mind that the officer has a legal basis for stopping the car, and that's because he has observed a traffic violation. The car was speeding. So the fact that the officer's true motive was to investigate the car for drugs does not mean that the stop was unlawful. Because, again, he has a legitimate basis for stopping the car. The car was speeding. So we can boil that all down to a rule here that says that if an officer has probable cause to believe that a traffic law has been violated, he can stop the car even if the officer's ulterior motive is to investigate whether some other law for which he lacks reasonable suspicion is being violated. So as unfair as it seems, this is still kosher. The fact that the real reason that the officer pulled the car over, lacked any reasonable suspicion whatsoever, is meaningless so long as he had probable cause to believe that a traffic law has been violated. So again, as unfair as this seems, the courts do sanction this. This came out of a case called Wren versus United States. And basically, in that case, it was decided in 1996, police were in a high drug area and they stopped the defendant's car after observing the defendant wait a long time at an intersection, abruptly turn without signaling, and speed off at a high rate of speed. In that case, the court held again that the traffic stop was kosher, and the mere fact that the officer lacked reasonable suspicion to conduct or to search for what to search for what he was really looking to stop the car for was meaningless. In addition, as long as the police do not extend the valid stop beyond the time necessary to issue a ticket and conduct ordinary inquiries incident to such a stop, it doesn't violate the Fourth Amendment to allow a narcotics detection dog to sniff the car. So now we're moving on to the situation where the car is actually pulled over, and perhaps the police officer has asked the driver or the owner of the car for consent to search. And perhaps in this case, the driver has denied consent, and because of the mobility involving cars and the fact that if there's something illegal in the car, it could be easily destroyed. What police oftentimes do is once they remove the occupants from inside the car, they call up the sheriff's unit to bring a canine down to do a sniff of the outer portion of the car. And if the dog indicates through signals that there is perhaps that he or she smells drugs, then that can lead to the police officers requesting an electronic warrant, or it can lead to the police officers putting a little bit more pressure on the driver or owner of the car to consent to a search of the car. So that concludes this podcast on automobile stops, and we'll be getting into, in the next podcast, evidentiary search and seizure, and going through a whole checklist of Fourth Amendment rights and what to look for when it comes to the invocation of the Fourth Amendment right, and when it is necessary for the police to obtain a warrant, and what type of exceptions to the warrant requirement exist. So stay tuned.